Let's talk about another part of the bill. The Counsel Fee Bill is intended to cure instances where parties have different economic resources. In situations where one party has significantly more assets or more income than the other, the less moneyed spouse will now have access to funds for attorney fees. First of all, what does it mean to be the less moneyed spouse? And does this legislation really cure its intended purpose?
Okay, let me answer the second question first by telling you this. The statute has always authorized a court to award counsel fees to what we refer to as the less moneyed spouse. The difference is because the courts were not following the mandate, we have this legislation, and I'll review it in a second. With respect to the first part of your question, which deals with what is the less moneyed spouse, we're going to have to find that out. We presume that they meant the less moneyed spouse was the person who made less money. I made $350,000 a year and you made next to nothing. But we know that I could make $350,000 a year, we could have $500,000 of assets, and your father could have given you $3 billion, in which case you'd be the more moneyed spouse, I'd be the less moneyed spouse. It's going to depend on the finances of every case. But if you look at the bill, you need to read the most important part, which is there shall be a rebuttable presumption that counsel fees shall be awarded to the less moneyed spouse. The aim is to assure that either party or each party shall be adequately represented and that where fees and expenses are to be awarded, they be awarded on a timely basis so as to enable adequate representation from the commencement of the proceeding, and the applications can be made at any time. There can be more than one application made. It's a clear signal to the courts, because this is not to counsel. This is a direction to the trial courts that we do not want you saying, wait a minute, we'll deal with counsel fees at the end of the case, which means that the less moneyed spouse would have a lot of trouble getting a good, competent lawyer unless they had a lawyer who had so much money he or she didn't care about getting paid till the end of the case. There aren't a lot of us out there today who could be like that. And it's a direction to the courts to say, make sure that less moneyed people have the wherewithal, assuming that their spouse has the money, to fight on an even plane. It's, from my point of view, the most ameliorating of all of the bills after we talk about no fault.
When they wrote this statute, do you think that their intention was to really clarify the fact that a couple getting divorced should be treated as an economic partnership?
I'm hesitating because that may be by indirection. I think that's not really where they were at that point when they did this bill. I think what they did within this bill was to make an announcement which goes as follows. If there is money in the case, the fact that I control it, it's in my name, or it's in a joint account which requires both of us to agree, should not disadvantage my spouse who does not have money in her name or in his name, or we have no joint money that we can agree on. It's really a leveling of the playing field. Let's talk about a traditional case. Traditional case, Westchester County. I keep my money in my name. I don't put it in joint names. I make all of the money and you're home taking care of the children. And now you want a divorce and you go to see a lawyer, and the lawyer gives you a wonderful consultation, explains the law to you, and then says, and by the way, I charge X dollars an hour, and I take a $10,000 or a $15,000 or a $20,000 retainer, which is refundable, but I expect to get my money up front. And you turn to that lawyer and you say, wait a minute, my husband makes $1 million a year. He's got lots of money in the bank in his name. He's frozen the joint accounts, and I have nothing. Prior to this bill, the average lawyer would have to look long and hard and decide whether he or she wanted to take the case. Now, certainly they can call up the other attorney and say, come on, you ought to pay my fee. I'm going to get it in the courthouse anyway. They could make an application to the court, but the courts were not granting these applications with the frequency and in the amount that the legislature has basically now said they should be doing, which is why there is a certain part of leveling the playing field and calling it a partnership. But let me talk about partnership for a second, because you're really talking about the equitable distribution law, which we've had for 30 years. In our state, title to an asset is not determinative of whether it's part of the marital pot. It's whether it was acquired during the marriage. Prior to 1980, if an asset were in my name, it didn't matter when I acquired it. It was mine and you had no rights to it. And equitable distribution changed that. And this is just a following up and a clearing up. Look, we have judges who get these cases in front of them. They are caught between, you'll forgive the expression, a rock and a hard place. If they feed too much in counsel fees, they believe it will only feed the litigation. If they don't provide counsel fees, then the dependent spouse doesn't have his or her champion. And so they've tried to balance it. And frankly, the legislature has said, you haven't done such a great job of balancing. We need you to be more aware of the needs of dependent spouses.
Will the court require an accounting of how legal fees are incurred, or is it basically an application and the application is either granted or it's not granted? How does that supposed to work?
Well, the court, that's a very good question. The court can require an accounting. First of all, when you ask a court for counsel fees, you don't just say, I want counsel fees because I want counsel fees. You say, I want counsel fees because I've just been hired. My client has told me the following issues exist in this case, and these are the things that I will have to do on his or her behalf. I may not have to answer a complaint because grounds are not an issue, but there may be custodial issues involved. There certainly are going to be financial issues involved. We have to identify the assets. We have to classify them. We have to evaluate them. And we know from the tax return that we have, which is all we have, that there are lots and lots of different assets because we looked at Schedule B and we saw all this interest income that this gentleman or this lady has and all the dividend income he or she is having. And we need to investigate where that comes from. It's based upon that, and I estimate it will take me so many hours to do this. It's based upon that a court will make an award. I think when you go back for a second award, a court's going to expect you to explain what you did and what is left to be done.
But Henry, what you just described, it was my understanding that's what the process was even before this legislation, wasn't it?
Well, the law authorized the court to do everything it now makes them do. I want to go back to the most important words in this bill. The statute contains incredibly important words. I said it before, let me say it again. There shall be a rebuttable presumption that counsel fees shall be awarded. That's a very different statement or language than the court is authorized to make an award of counsel fees. A presumption means we expect you to do it absent unusual circumstances. It's the thing to do. It's the requirement. Here, give you one other statement. If you read the sponsor's memo, all of our bills have a bill and the memo for the sponsor. And after saying it creates a rebuttable presumption of counsel fees to the non-moneyed spouse as well as expert fees, that's an important thing to keep in mind. When we apply for counsel fees, we also can apply for expert fees for the experts who value the assets of this marriage. The memo says, the current law places the onus on the party seeking counsel fees to show why the interests of justice require an award of fees, and judges appear to be reluctant to award fees under the current statute. Because an award of fees is vital to prevent an imbalance in resources, we need a presumption of an award of fees, and that's the difference. This is simply saying, we try to tell you this in a couple of amendments over the years, courts, but we must have you awarding counsel fees.
Now, you just mentioned expert fees. Does this section address expert fees any differently than how expert fees, whether it be for child or forensic accounting or anything else, is it going to be treated now differently than in the past? Okay.
Probably, but now we got to do a little history, okay? Before you could get counsel fees in the past, we used to have what's called an Ahern affidavit. You'd get an affidavit from a forensic accountant explaining what the business that he or she was going to evaluate and what he or she thought it would cost. And you submitted that with your application for expert fees and counsel fees. When we got to preliminary conferences, directions seem to change. And we go in on a permanent conference, and the court says, so what do you got in this case? And we say, well, we have a medical practice to evaluate. And the court says, okay, I'm going to appoint this person or that person. So there's been a shift away from the time-consuming Ahern affidavits into a recognition by the courts that when you can identify that there's something that they know has to be evaluated, a medical practice, a law practice, a business, the enhanced earning capacity that people acquire during the marriage, the courts are much more readily appointing experts as a matter of course. And so what do you need for counsel fees? Who are we going to pick? The courts may pick the expert they want on their own, or they may ask for a list from the attorneys to see if they can agree on something, and may very well fix the amount of money to go. But the courts, I believe, have been actually much more willing to award expert fees than counsel fees over the last number of years.
Do you think it's because they just want to move the case along and they think that maybe by appointing the neutral, it's easier and quicker?
They certainly know that you can't settle a case without an evaluation.
You know, before we go to the next topic, let me just ask you one other question in reference to counsel fees, since I'm sure our audience is particularly interested in this part of the legislation. Is there anything in the legislation to address when one or more of the parties changes counsel?
Well, there is nothing in the legislation. But remember, the courts still have discretion. And the courts are, I don't believe, and I've said this before, I don't believe this bill is a blank check to anybody. I believe it authorizes a court to assist a non-moneyed spouse or a less moneyed spouse in defense or in the prosecution of an action for divorce. But I believe when you see people changing lawyers multiple times and making multiple applications through different counsel for legal fees, I think the courts are going to not be as willing to make an award at that time as they would have been to the first or maybe the second lawyer. So the people who go through 4, 5, 6 lawyers, I don't think are going to be helped by this. They better have their own monies.
Let's talk about the temporary maintenance guideline bill. This bill, I believe, was to allow for a speedy resolution of maintenance issues. What are its strengths? What are its weaknesses? And what are your general comments about this part of the legislation?
Let's start with, I don't think it has any strengths. I think that if before you can talk about the temporary maintenance bill, you have to understand the history of what went on in the legislature, because the temporary maintenance bill was not what was going to be proposed and passed. Maintenance in this state is discretionary with the court based upon a number of factors in the statute, both temporary and post-divorce maintenance. It's primarily been based upon needs and standard of living. There are lots of other factors which go into it, but certainly on a motion for temporary maintenance at the beginning of a case, the concept was, how do we keep the status quo? How do we keep these people so that they're not in foreclosure, so that there's food on the table, so that there's clothing on their backs, while we sort out the mess of what assets exist, what income is really being earned, and what's the ultimate resolution?